Bismillahirrahmanirrahim. Assalamu alaikum, dear students. In today's lecture, we will be continuing our previous discussion about the Pakistan Environmental Protection Act 1997. In the previous two lectures, we studied some of the sections of our this Environmental Act. Today we will continue those sections. In our previous sections, again, our some of the basic sections were related to the initially were related to the definitions, establishment of Pakistan Environmental Council. Then we have functions and powers of that council. Then we studied the establishment of Pak Environmental Protection Agency, then its functions and then its powers. And then in the next lecture we studied the section number 8, in which we studied something about the provincial environmental agencies, and then their establishment and its powers and its management. All these things we studied in previous lecture. Then we also studied something about the management of provincial sustainable development fund, and continuing to those, there was another very important section that was about the provision of certain discharges or emissions. And then we also studied a very important section about the initial environmental examination and environmental impact assessment, and it's something about the guidelines, how IEE and EIA will be conducted, who will be monitoring it, to whom the report will be submitted, what will be the consequences if there is some non-compliance, and how it will be managed. Furthermore, we studied about the provision of impact of hazardous waste in section number 13. In section 14 we studied about handling of hazardous waste, and then in 15th section we studied about the regulations of motor vehicles. We had environmental protection order, then we had penalties in section 17, and then in 18 we had offenses by the bodies corporate. It was about the lying responsibility on some designation, because these are the government institutions, and who will be the responsible if some discrepancy is being observed from that government organization. So some rules about that we try to study. Then we finally studied something about the environmental tribunals. So what are the environmental tribunals? These are the government bodies which will be having judicial powers. They can implement penalties, they can enforce law. So something about that. Now today we will continue our the remaining sections of the Environmental Protection Act, and continuing to the environmental tribunals establishment. We will be talking about the jurisdiction and powers of environmental tribunals. So what is the jurisdiction and powers of environmental tribunals? It is actually something about the scope and the limits of these tribunals, what these tribunals maximum can do, and what are their limitations. So this section is going to deal with such rules and regulations. So if you have its subsections, have a view on its subsections, you can see that the environmental tribunal shall exercise such powers and perform such functions may be conferred upon or assigned to it by under this act or rules made there under. So it is actually going to exercise all the powers falling in this act. And then how to proceed? We have a very important subsection which is covering that all contravention punishable under subsection 1 of section 17 shall be exclusively be triable by an environmental tribunal. So, what is section 17? If you recall, it is something about penalties. And then what is subsection 1? It is dealing with the penalties related to section 11, 12 and 13. So it was something about provision of certain discharges, IEE and EIA, and then provision of impact of hazardous waste. So very important topics related to environment are covered in these sections, section 11, 12 and 13. And if you revisit section 13 with the heading of penalties, you will find that there is a limit to be a limitation of amount which is specified by this act, and under this act the environmental tribunal can make its decision, can have its verdict. So please have a look on section 13, section 17 and then its subsection 1. It will clarify what this tribunal, environmental tribunal, has the power to do. And in the third subsection you will see that environmental tribunal shall not take cognizance of any offence tribal under subsection 2 except on complaint in writing by. So it's for the subsection 2, and subsection 2 is again as described above, and it is in it is describing that unless it is some the environmental tribunal is having having a complaint in written from the federal agency or any government agency or local council or any person who has been suffering from the environment, the environmental tribunal cannot hold the court. Environmental tribunal is only capable, is only having the scope to have its verdict only if it's going to have a complaint through these two options, which are firstly ordered in written by a federal agency or a aggrieved person. So both cases the tribunal have the authority to conduct its court and have its verdict. Otherwise, it is not authorized to do anything on its own. And then furthermore, in exercise of its criminal jurisdiction, the environmental tribunal shall have the same powers as vested to the court of session. So session court powers are being legalized for the environmental tribunal to exercise. Similarly, here we have another Code of Civil Procedures of 1908, under the jurisdiction of which this tribunal can exercise its powers. Further, so continuing to the jurisdiction of the Environmental Tribunal, you can see in all matters with respect to which no procedures has been provided for in this Act, the Environmental Tribunal shall follow the procedures laid down in the Code of Civil Procedure. So it is kind of an additional edge provided to the tribunal, that if there is some discrepancy in this law, which is the law is not covering the issue being proposed in front of the tribunal, in that case it has the authority to decide based on the Code of Civil Procedures 1908. Fine. So in this section, subsection 7, Environmental Tribunal may, on application filed by any officer duly authorized in this behalf by the Director General of Federal Agency or Provincial Agency, issue bailable warrant to arrest any person. So it is again the jurisdiction of tribunal to issue the bailable warrant to arrest any person who is having contravention under the subsection 1 of section 17. So the remaining are some provisions which you can go through. So important is only up to this subsection 7. Then we have subsection 8. All the proceedings before the Environmental Tribunal shall be considered to be judicial proceedings within the meaning of section 193 and 228 of the Pakistan Penal Code. And so it is giving it our legal authority that the what the proceedings have the value, and how it is equivalent to our other court procedures. So no court other than a tribunal shall have or exercise any jurisdiction with respect to any other with respect to any matter to which the jurisdiction of an environmental tribunal extends under this Act. So only Environmental Tribunal has the authority to extend its jurisdiction under this Act. No other court can do it. So where the tribunal is satisfied that the complaint under the subsection 3 in the previous, as we talked about, is false and vexatious to the knowledge of the complainant, it may be in order direct the complainant to pay to the person complained against such compensatory cost which may extend to 100,000 rupees. So something expressed here, if you see this, the third section, subsection, in which the Environmental Tribunal is having the authority to have its verdict, to have its hearing. Only in this case, and if it's following the subsection 3, and then it is found that the person who was accused is not found guilty, in that case the reverse can take place. The person who actually accused can be asked to pay the penalty of 100,000 rupees as described in the subsection 10. So it was something very detailed description about the jurisdiction of the tribunal. So appeals to the Environmental Tribunal. So if someone wants to appeal against the Environmental Tribunal, in that case, within 30 days, it has the authority that it can appeal within the 30 days. So, it is appealed to the Environmental Tribunal, not against the Environmental Tribunal. So anything which was decided by the federal agency and by the provincial agencies or local community, agencies, in that case, the appeal to the environmental tribunal can be uh, made within the 30 days. And an appeal to the environmental tribunal shall be in such form with all the particulars along with the fees, so not much. So appeals from orders of the tribunal. So this is something against the environmental tribunal, and in this case any person aggrieved by any final order or by any sentence of the environmental tribunal within passed under this act may within 30 days of communication of such order or sentence prefer an appeal to the High Court. So the person will have to go to High Court if he or she wants to appeal against the environmental tribunal. So in that case, as described in subsection 1, there must be a bench not less than 2 judges who will be hearing that case. Now, what is the jurisdiction of environmental magistrates? So magistrates have something, again, working along with the tribunals. So how they are going to make their decisions and what are their jurisdictions. So notwithstanding anything contained in the code or any other law, all the contravention punishable under subsection 2 of section 17 shall exclusively but be triable by a judicial magistrate of the first class as environmental magistrate, especially empowered in this behalf by the High Court. So what is this? It is actually the description how you can directly have the implication of the law through magistrates. So subsection 2 of section 17, if you go back and have a look at it, it is dealing with the something about the motor vehicles and something about the handling of the hazardous waste. That is sections 14 and 15. So if there are some issues related to section 14 and 15 in focusing on the handling of the waste and the motor vehicles only, in that case environmental magistrates can directly have their influence, and then they can make their own decisions maybe at the spot. So shall be competent to impose any punishment specified in subsection 2 and 4 of section 17. So again it's the same thing, and an environmental magistrate shall not take cognizance of any offence triable under this subsection except on a complaint and writing. So the magistrate is only going to have a hearing if it is going to have some direct application from the federal agency or government agency, local council, or the person who is suffering. So appeals from orders of environmental magistrates. So again it is any person convicted of any contravention of this act or rules or regulations by an environmental magistrate may within 30 days from the date of his conviction appeal to the court of session court, whose decision thereon will be final. So power to delegate. What are the powers? How the powers are being delegated? Federal government may by notification in the official gazette delegate any of its or of the federal agency's power and functions under this act and the rules and regulations made thereunder to any provincial government and any government agency, local council or local authority. So that means the federal government can notify and transfer the powers to the agency and to the regulatory bodies or local authorities, so provincial government, anything that has to be done through the notification in the official gazette. Second is again the same thing, and but it is for the provincial government. So the provincial government again has the powers to notify in the official gazette any kind of delegation of power to the provincial agency, and or any government agency such a provincial government or any local council or local authority in the province. So the power to give directions. So who is going to direct? The performance of their function under this act, the federal agency and provincial agencies shall be bound by the directions given by the federal government, and provincial agency shall be bound and by the directions given to it in writing by the provincial government. So it is like the transfer of it is like the chain of command, how the directions will be given. So again, it's if it's federal government jurisdiction, then federal government has the powers to convey its directives to that agency. And if it's provincial government, then the provincial government has the powers to have a directive for the provincial agency. Now it is something about the indemnity. So no suit or prosecutions or other legal proceedings shall lie against the federal or provincial governments, the councils, the federal agency or provincial agency, the director general of federal agency, and the provincial agency members, officers, employees, experts, advisors, committee or consultants of the federal or provincial agencies, or the environmental tribunal or environmental magistrates, or any other person for anything which is in good faith done or intended to be done under this act, or the rules of the regulation or regulations made there under. So that means all these authorities which we named here cannot be directly prosecuted. You can never have a case directly against them as long as they have done something in the good faith. They can be exempted from being execution. So dues recoverable as arrears of land revenues. So then it's again a very simple one. Any dues recoverable by the federal agency or provincial agency under this act or the rules or regulations made thereunder shall be recoverable as arrears of land revenue. So act to override other laws. So the provision of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So if there is any law which is in contradiction to this law, then this law will be superior to it. So this act will withstand. So powers to make rules. So federal government again through the notification make rules for carrying out the purposes of this act, including rules and for implementing the provision of the international environmental agreements specified in the schedule to this act. So schedule is provided in the end of this act, which will be covering all the international treaties and rules and international laws, so which are supposed to be abided by the federal government. So this federal government is going to make such rules, first of all, to facilitate the implementation and provision of the international agreements. So in simple words, we have a schedule in the end of this act, which is covering all the international environmental agreements and treaties and laws. So the federal government may, by notification in the official gazette, can make rules for carrying out to the implementation of those laws as well. Is it clear? Again, I will simplify. We have a schedule in the end, which is covering all the environmental international agreements. So the federal government can make rules for their implementation. Powers to amend the schedule. The federal government may, by notification in the official gazette, amend the schedule so as to add any entry or to omit any entry. So the federal government has the power to add any treaty in the schedule or remove any treaty from the schedule. So anything which is going to be done must be a directive from the federal government. Powers to make regulations. So regulations are actually supporting directives to facilitate the implementation of this act. What are those? So, for carrying out the purposes of this act, federal agency may, by notification in the official gazette and with the approval of the federal government, make regulations not inconsistent with the provision of this act. Simple. So what kind of those regulations can be which are going to facilitate? Number one, submission of periodical reports about data and about the environmental matters. Then preparation of contingency plans, emergency contingency, something which is going to happen in future. We must have a plan, a foresee of that something which is not predicted now. We should be ready for that. So appointment of officers and others is again the federal agency going to make the rules. And then levy of fees, how it is going to happen, it is again through some regulation. Monitoring and measurement of the discharges and emissions, it is supposed to be done by the government agencies, federal government and the federal agencies. So then we have guidelines for IEEE and EIA, which is to be developed and have to be implemented. Then providing procedures for handling hazardous substances, it is again the regulations done by the agency. Installation of devices, it is supposed to come through the agency again, so we need some rules and regulations for their implementation. So the best example of this is the zigzag policy for the brick kilns, which is going to have a high impact of smog. So the provincial and federal agencies have made rules and regulations that all the brick kilns must adopt this technology, zigzag technology. Otherwise, they will be not able to work in the winter season. So please go through this example as well. So repeal, savings and successions, these are something about the transfer of the provisions. And if we go into the details, so everything which was earlier falling in the under the heading of the ordinance 1983 is now being transferred in under the heading of this act. So again we are supposed to continue following if it is in the same it has the same implementation. And then the established under the ordinance shall vest properties, assets, liabilities. So everything which was initially under the federal agency, but as ordered by the ordinance, now it will be under this act and again transferred to the federal agency. So now this act is giving a cover to the transfer of all the assets again to the same agency. So that was something about the Environmental Act. Basically, the purpose of understanding and going through the details of all the sections was to have an idea how we normally make our laws. What are their limitations? What are their scope? How we can observe these laws in our daily life and in our daily procedures. How we can improve these laws, how we can improve the control of the government to implement these laws. All these things are important to understand. And furthermore, it is just the giving us a wider cover. Under this cover, we have so many other things which are falling. So continuing to this, I will again request you to have a look at the website, and there are so many other options which are available. So the Clean Air Act and other NEQS, all these things are in support of this act actually. So we will continue with the regulations now. What kind of regulations have been made, like IEEE, EIA, and how we are benefiting our society by making such laws and regulations. What is our role as a consultant and as an environmental engineer? So that is important for us. Thank you very much for today's lecture.